Okay, let's unpack this. Have you ever lived in a complex or, a neighborhood with shared spaces?
Hmm.
Like a sectional title, a homeowners association, maybe even a retirement village?
Yeah, lots of people have.
Exactly. And if you have, you've probably hit a few of those community living moments, right?
Oh, definitely. Disagreements over levies.
Right. Or maybe a pet causing problems or arguments about how the pool area is managed, that sort of thing.
Exactly.
Well, the material you've brought us today dives right into that, how a specific piece of South African law tries to bring some order, some fair resolution to these really common challenges.
Yeah, it's fascinating, actually. We're looking at the Community Schemes Ombud Service Act, CSOS Act number 9 of 2011.
Okay.
It officially kicked off October 7th, 2016. And it provides this comprehensive framework. The goal is really to streamline how disputes get solved and, just as importantly, promote good governance in these community schemes.
Right.
So our mission in this deep dive is basically to pull out the key bits from the Act, explain its purpose, the main provisions, the legal background, and what it means in practice.
And make it clear for everyone, right? Whether you're just living in one of these places or maybe you're a law student needing an overview.
Precisely. Clear and engaging, that's the aim.
Okay, crucial topic.
Yeah.
So let's start at the beginning. What's the Act really trying to do? And what does it actually mean by a community scheme?
Right, so the core purpose, Section 2 lays it out. It's threefold, really. First, establish the Community Schemes Ombud Service itself, the CSOS.
Okay, the service provider.
Exactly. Second, define its functions, how it operates, its governance structure.
How it works.
And third, and this is probably the big one for residents, provide a specific way to resolve disputes within these schemes, a dedicated mechanism.
So set up the problem solver, define how it runs, and create the actual process for solving the problems. Makes sense. Which leads to that definition. What is a community scheme then?
Good question. Section 1 defines it quite broadly. Essentially, any arrangement where there's shared use and shared responsibility for parts of land and buildings.
Shared space, shared responsibility.
You got it. So if you own your own unit but share common areas and costs with others, this act probably applies.
Okay.
And it lists specific examples too. Sectional title schemes, share block companies, home or property owners associations, whatever they call themselves.
Ah, so the name doesn't matter so much.
Not really if the structure fits. It also includes housing schemes for retired persons and housing cooperative. It casts a really wide net.
It does sound like it covers almost every kind of complex or managed estate living. Who are the key players the Act mentions?
Yeah, it's meant to be comprehensive. Key roles defined are the association, that's the body in charge, like the body corporate or HOA.
Right. The management committee, essentially.
Usually, yes.
Yeah.
Then there's the owner, someone with a legal right to occupy a specific part, like a flat or house. An occupier, anyone legally living there, maybe a tenant, not necessarily the owner. And the managing agent, the company or person paid to help run the scheme.
Got it. Association, owner, occupier, managing agent.
Uh.
Okay, so we know the landscape. Now, the CSOS itself, the Ombud Service, what kind of entity is this?
Okay, the CSOS, it's established as a juristic person,
Meaning
it's a legal entity in its own right, separate from the people working there, like a company.
Okay. It can sue and be sued, that sort of thing.
Exactly. And it operates as a national public entity. This is important. It falls under the Minister of Human Settlements.
So direct government oversight?
Yes, and it means it's subject to the Public Finance Management Act, the PFMA. So strict rules about financial management and accountability apply. It has a head office and regional offices, too, for accessibility.
Right. Proper structure, proper financial controls.
Yeah.
So what does it actually do? What are its core functions for these community schemes?
Well, its main job, the one people hear about most, is providing that dispute resolution service.
The problem-solving part.
Right. But it does more. It's also meant to be a kind of quality controller and information hub. It regulates and monitors the quality of scheme rules, the governance documents.
So like checking if the complex rules are fair or legal.
Exactly that kind of thing. It also keeps custody of these documents and makes them publicly accessible, promotes transparency.
Okay.
And beyond that, it actively promotes good governance through education training for owners, occupiers, trustees, directors, and generally monitors how schemes are being run.
Interesting. So it's reactive with disputes, but proactive with governance and education.
Yeah.
How is all this formalized? Is there like a performance contract?
Yes, there is. Section 5 talks about a written mandate between the minister and the service. It's quite detailed.
Oh.
Yeah, it includes specific performance indicators, service delivery targets, even what to do with surplus money, and it gets reviewed every 5 years. Keeps them on track.
Okay, so there's accountability built in. Who's steering the ship then? Who makes up the board?
The board is key for oversight. It's a mix. 2 executive members, usually the chief ombud and CFO, and 7 non-executive members. The minister appoints the chairperson and deputy from the non-execs.
And how do they pick these non-executive members?
There's a process. Public nominations are invited, then a nomination committee, which includes people like parliamentary committee chairs, makes recommendations.
What are they looking for?
Specific skills, really. Section 7 lists things like risk management, financial management, obviously dispute resolution and community schemes, public education, scheme management experience, governance documents, even scheme development. They want a broad base of expertise.
Makes sense. Not just figureheads, but people who understand the nitty-gritty.
Hopefully, yes. And they have strict rules, too. Fiduciary duties.
Meaning they have to act in the best interests of the service?
Exactly. Utmost good faith, honesty, diligence. They have to declare any financial interests, especially ones that might conflict.
Like if they own units in multiple schemes or run a managing agency?
Precisely. They'd have to declare that and step back from decisions where it creates a conflict. There are also clear disqualifications, things like insolvency, serious criminal convictions for dishonesty, being removed from a position of trust before.
Right, ensuring integrity at the top. And day-to-day, who runs the actual operations?
That mainly falls to the chief ombud. They're the head of administration, manage the staff, implement board policies, set up the systems.
Yep.
And working closely with them is the chief financial officer, the CFO, handling all the financial management, risk, compliance with the PFMA, budgets, making sure the money side is sound.
And they're appointed competitively too, I assume.
Yes, the board appoints them with the minister's approval based on qualifications and experience.
Okay, so we have the board, the chief ombud, the CFO. Who else is on the team dealing with the actual cases, and where does the money come from?
The chief ombud appoints the regional ombuds, deputy ombuds, and the adjudicators and conciliators. These are the folks handling the dispute applications. They all need relevant qualifications, too.
Right. The front line.
Pretty much. As for funding, it's a mix. Some money comes from Parliament, but a significant portion comes from levies collected directly from community schemes.
Ah, so schemes pay an annual fee.
Yes, a prescribed levy approved by the minister. Plus, they can charge fees for certain services, earn interest, get grants or donations, and again, all managed under PFMA rules.
Okay, levy funding is interesting, right? Let's get to the core of it for many people, the dispute resolution side. How does someone actually start a case?
Okay, Section 38. Basically, anyone who is a party to or is materially affected by a dispute can apply.
How it counts as a dispute?
It has to be about the administration of a community scheme, and one of the parties has to be the association, an owner, or an occupier.
So internal scheme issues.
Exactly. The application has a set format, you lodge it with an ombud, pay a fee unless you qualify for a waiver, and you have to state clearly what outcome, what relief you're seeking, who else is involved, and the reasons why.
Right. And what kind of relief can you actually ask for? What orders can the CSOS make?
Yeah.
This must be where it gets really practical.
Absolutely. Section 39 is really the heart of it for many disputes. It lists specific types of orders an adjudicator can issue. It's pretty extensive.
Okay, give us some examples. What about money issues? Levies are always a big one.
For sure. Under financial issues, an adjudicator can, for example, order the association to get proper insurance or increase its cover. They can declare levies unreasonable or incorrect and order them to be adjusted, even order repayments.
Wow, okay.
They can order a financial audit, and here's a powerful one. They can order a tenant to pay their rent directly to the association if the landlord owner is behind on their levies.
Really? Reroute the rent. That's significant.
It can be, yes. It directly addresses the association's cash flow issue caused by the owner's debt.
Okay. What about those neighbor-type disputes? Noise, pets, that sort of thing?
Yes, behavioral issues. An order can declare someone's behavior a nuisance, like constant loud parties, and require them to stop. Regarding animals, if a pet is genuinely causing a nuisance or breaking the rules, an adjudicator can order the owner to sort it out, or in some cases, even order the animal removed.
Okay, that's direct.
Same for things illegally stored or built on common property or even someone else's private area, they can order removal.
Deals with encroachments and clutter. What about the rules themselves? Or meetings? Those cause so many arguments.
Big area, scheme governance issues. An adjudicator can order new rules to be formally recorded, or, importantly, they can declare existing rules invalid or unreasonable.
So they can strike down bad rules.
Yes, and require them to be changed or removed. For meetings, they can force an association to call a general meeting if it's overdue.
Useful if the committee is dragging its feet.
Definitely. Or they can declare a meeting or a resolution passed at a meeting invalid. Maybe proper notice wasn't given or procedure wasn't followed.
Okay.
They can even declare a motion passed if it was unreasonably blocked, or declare a resolution void if it unfairly impacts someone's rights. It keeps the democratic process in check.
What about managing agents? Can CSOS step in there?
Yes, management services. They can order a managing agent to stick to their contract or the code of conduct, or they can make a declaration on whether the association has the right to fire their managing agent. Gives clarity.
Okay. And repairs. Maintenance. Common property stuff.
Yeah.
Always contentious.
Huge area. Works pertaining to private and common areas. An adjudicator can order the association or an individual owner to carry out necessary repairs or maintenance.
Both ways.
Yes. They can order specific work on common areas for safety or convenience, or even stop proposed works. If the association unreasonably refuses permission for, say, an owner wanting to make reasonable improvements, the adjudicator might override that refusal.
Interesting.
They can even grant someone exclusive use rights over a part of the common area, perhaps if it's necessary, and the association refused unreasonably, often setting conditions like payment.
That covers a massive amount of ground. So once someone applies, what's the ombud do first? Do they vet the applications?
Yes, they do. The ombud might ask for more details or proof that the scheme's own internal dispute process was tried first.
Encourage self-resolution first.
Exactly. And they must reject an application if it's outside their jurisdiction, if the applicant doesn't provide info, if it's clearly a matter for the courts, or if a fee waiver request isn't justified.
So there's a gatekeeping function if it gets past that.
If it's accepted, the ombud notifies everyone affected. Then, if there seems to be a reasonable chance of settling it amicably, the ombud refers it to conciliation.
Mediation, basically.
Pretty much. A facilitated negotiation to try and reach an agreement without needing a formal order. It's a really important step.
And if conciliation doesn't work?
Then, Section 48, the ombud refers it to an adjudicator. The adjudicator takes over the case file. Fees usually need to be paid or secured at this point unless waived.
Okay, adjudication time. How does the adjudicator investigate? Is it like a mini court?
It's less formal than court. The Act stresses they must observe due process but act quickly with minimal formality. They aren't strictly bound by the rules of evidence used in civil courts.
Makes it more accessible, maybe less legalistic.
That's the idea. They can consider a wider range of information more flexibly.
Do they have powers to dig for information?
Oh, yes. They can demand documents, affidavits, conduct interviews. They can ask for written submissions from anyone who might help. And interestingly, they have the power to enter and inspect.
Inspect what?
Association records, assets, common areas, even private areas with reasonable notice, of course. And associations must give them access to records within 24 hours, free of charge, if requested.
That's quite intrusive, but probably necessary sometimes to get the facts straight.
It's a strong tool for verification, yes.
What about lawyers? Can people bring legal representation to the adjudication?
Generally, no. That's a key principle. Parties are not entitled to legal representation by default.
What's that?
To keep it low cost, accessible, and less adversarial for ordinary people. However, there are exceptions.
Such as?
If all the other parties agree, or if the adjudicator decides it would be unreasonable to expect someone to cope without a lawyer, maybe because the case is very complex legally, or there's a big imbalance in the party's ability to present their case.
So it's mostly self-representation, but with a safety valve for complex situations.
Yeah.
What happens after the investigation? What kind of decisions come out?
The adjudicator can dismiss the application if it's frivolous, vexatious, meaning purely intended to harass, misconceived, or just not backed up by evidence. They can even order costs against the applicant in some dismissal cases.
Right.
If it's not dismissed, they issue an order. This grants or refuses the relief sought, explains the reasons, and tells parties about their right to appeal. The order will specify who needs to do what and by when.
And do these orders actually carry weight? How are they enforced?
Yes, they carry the weight of a court judgment. Section 56 is clear. If it's an order for money or something a magistrate's court could handle, it's enforced like a magistrate's court judgment.
Okay.
If it's something more complex, maybe involving property rights beyond that level, it's enforced as if it were a high court judgment. The court clerks or registrars have to register the CSOS order.
So they are legally binding and enforceable. That's crucial. What if you disagree with the adjudicator's final order?
There is a right of appeal under Section 57, but, and this is important, you can only appeal to the high court on a question of law. Meaning you can't just re-argue the facts or say you don't like the outcome. You have to argue that the adjudicator made a mistake in applying or interpreting the relevant law.
Okay, a legal challenge, not a factual one. And there's a time limit.
Yes, 30 days from when the order was delivered. You can also ask the high court to pause the order while the appeal is heard.
Got it. Okay, wrapping up with some general points. Can the public see past decisions? And what about those levies you mentioned earlier?
Yes, for transparency, the Ombud makes past orders and the reasons available for public inspection. Helps people see how similar issues were handled. And the levies, yes, Section 59 makes it mandatory. Every community scheme must pay the prescribed annual levy to CSOS.
A compulsory contribution.
Yes. And they also have to file an annual return with CSOS, submit their financial statements, and potentially other documents. It's an ongoing relationship, not just when there's a dispute. It helps fund the service and allows for oversight.
That ongoing filing requirement really embeds CSOS into the governance structure, doesn't it?
It absolutely does. It reinforces that continuous oversight role. A couple of other important points. The independence of the service personnel, especially in dispute resolution, is stressed.
So the Ombud steps back once it goes to adjudication.
Correct. And the key personnel chief, Ombud's adjudicators, have privileges and immunities similar to a high court judge when doing their job. Protects them from liability, including for defamation.
Important for impartial decision-making and penalties for noncompliance.
Yes. Section 34 outlines offenses. Things like obstructing officials, giving false info, not providing access, conflicts of interest, they carry penalties, potentially fines or even imprisonment. It shows the act has teeth. So if you step back and look at the bigger picture, what this act really does is acknowledge how vital and sometimes difficult managing shared living spaces is. It creates a dedicated formal way to resolve conflicts that's meant to be more accessible and cheaper than going straight to court. It provides structure.
The specialized forum.
Exactly. And it really makes you think, doesn't it? Could this kind of specialized ombud service be a model for other areas where resources or spaces are shared beyond just property? Something to mull over.
That's a great question. So what this means for you, the listener, is that if you're in a community scheme, there's a clear system. It empowers individuals and associations with processes with potential remedies. The aim is more harmonious, fair shared living, backed by a system for when things do go wrong.
Hopefully making community living a bit smoother for everyone involved.
Definitely. Well, thanks for taking us through this act today. A really important piece of legislation clearly explained. It sheds light on the legal framework supporting millions of people's daily lives.